sex crimes, I think, under the, or however.
It's on the sex crimes chapter.
Yeah, the sex crimes chapter. However, in my experience in doing domestic violence cases, similar to the stalking incident, we have been able to use this phrase specifically in circumstances where corroboration or there isn't corroborating evidence. Yes, it was meant for sexual assaults, but the idea, and I did allude to the questions that I asked, generally it'll be yes or no. And then if further clarification needs to happen, we will make sure that that happens. Okay, thank you. Does he own, or is there a car, dark colored Saturn registered to him, to your brother Sebastian?
That is correct.
Okay, yes. Thank you. And you do reside with him, and you did, sorry, let me take a step back. Did you reside with him in 2002 or 2022 as well?
Yes.
Okay, thank you. And the car that you have registered in your name, is it correct to say, or would it be fair to say it's a black Range Rover?
That is correct.
Okay.
Yes. Is there a year to be more specific?
What year is your black Range Rover?
I just want to.
No, I'm asking you.
Oh, mine's a 2013.
Thank you.
I believe the complaining witness says something.
No, I'm just asking yes or no. Thank you. And is it fair to say that you were aware at the time that Miss Green did not want you going over her home around July and August of 2002, that you were aware that she did not want you going to her house?
Hold on. I think you said 2002. I'm assuming you meant 2020.
I meant 2022. Thank you.
No, she's lying. That's a lie. That's not true. I was invited.
Okay, so what I'm asking though, that's not what I asked. I'm asking whether or not you were aware by July of 2022, whether or not she wanted you to be at or near her home.
Yes, she did.
She did?
Yes, I approve.
Okay, that's not what I'm asking. Did you send a text message to your son indicating that you were aware that Miss Green did not want you at or near her home?
7/19/2022 when she called me.
Okay,
in retaliation.
Mr. Phillips, please. My question is, were you aware of whether or not Miss Green wanted you to be at or near her home in July of 2022?
7/18 and prior, yes.
Okay, and there was an indication that she did not want you to be at her home?
7/19/22, yes, correct.
Okay.
And
that you had in fact told your son that you knew that you did not, that Miss Green did not want you at her home in July, at the end of July of 2022.
That was a text to him?
Yes.
That is correct, after the fact of her calling me?
Mr. Phillips, please, thank you.
Yes.
So it's fair to say that this is not someone that you had a cordial relationship with, correct? Miss Green is not someone that you had a cordial relationship with.
We did have a cordial relationship 7/18 and prior, which is striking. That's the whole premise of the matter. Is very striking, all of these false allegations, because I have proof of our interaction 7/18, whereas I was invited in days prior.
Okay.
So as of July and August of 2022, did you have a cordial relationship with the lady?
7/18/22 prior, Your Honor.
That would be a no. You didn't have cordial relationships in 22.
No.
I'm sorry.
July 18, 2022, you were fine.
Yes.
Okay.
Okay, so your testimony is that with this individual, that you two did not have any problems prior to July 18, 2022.
Well, I moved back to the state 8/20.
Is that a yes or a no?
It's 21 to 22.
From prior to your statement that you just made, prior to July 18, 2022, did you have a cordial relationship with Miss Green?
Yes, it's within the bracket of 8 of 2021 to 7/18/2022.
Okay, so
I moved back to Michigan at that time.
Okay, thank you. And so, Miss Green testified that essentially she had shared with you that she did not want you around her. Did you hear that testimony? You were sitting here. Did you hear her say that? That essentially she did not want you coming by her home?
I did hear that.
Okay, and that she had blocked your phone number. Is that correct?
That's incorrect.
No, did you hear her say
Oh,
that she had blocked
yes,
your phone?
I did hear her say that.
Okay, and so now your testimony is that she did not block your phone number?
She was blocked January 3rd of 2022, post me making a complaint at Romulus Police Department for using my son's American Express card
Okay,
under my name.
so, Mr. Phillips, that's different than what you just stated. You said that you guys had a cordial relationship up until July of 2022. Now you're indicating that something was blocked or that she was blocked because of other things that happened in January 2022. So that means you did not have a cordial relationship with her.
No, we did. We
Okay.
got through that.
Mr. Phillips,
November to
please.
January was the credit card usage. And once I went to Egypt and found out, I then responded via text to my son, to her. I was going to the basketball games
Mr.
at
Phillips, I'm not
Romulus.
asking about specific
Okay,
things
I'm just,
in regards to what happened in January. All I'm asking is that there was not communication between you and Ms. Green prior to July of 2022 by phone between either one of you.
can you please repeat that?
Is it your testimony, yes or no, that Ms. Green had not blocked you prior to July of 2022?
That is correct.
Okay. And is it your testimony that, let me take a step back. When you, were you aware that the drop off and pickup for Jalen was supposed to happen at the Livonia Police Department?
I'm aware of the court order.
Okay, so yes or no?
Yes.
Okay, thank
Yes.
you. And so there was a location that was selected in Livonia, at the Livonia Police Department, for you guys to exchange your child. Is that fair to say?
We were not following the order. We were in agreement.
That's not what I'm asking. Is that what the order indicated for you to go to Livonia Police Department?
That is correct.
Okay. And is it fair to say that there was likely a reason why the Livonia Police Department was the location of which the two of you were to meet? Is that fair to say?
I'm gonna object.
There's a prior history.
Hold on, there's an objection.
As to speculation and relevance of why a judge ordered it to be done there or not, I mean, we're not getting into the family court's decision yet. So that's what the order says. It speaks for itself.
Well, I'll
Why
take
was-
judicial notice that the court probably had a reason to pick Livonia.
Probably did. I
Do
don't
we
know
need
what-
any more than that?
Well, Judge, and maybe it was just the way my questioning was phrased. Is
Rephrase
because,
and we'll see if Mr. Cujo objects
Okay.
to the new one.
I'll come back to it, Judge.
Okay.
And Mr. Phillips, you know where Miss Green lives?
Yes, I do. My son
Okay.
lives there.
Yeah, so you're aware of the location in Romulus?
Yes.
Okay,
Her mother is the homeowner.
okay,
Never had an issue there.
Okay.
okay. And it's something where you have, it's fair to say that you've gone there several times, like you're aware of the neighborhood, you're aware of the location.
That is correct.
Okay,
I enrolled him in the summer school. I enrolled Jalen, our son,
Oh,
in the
okay.
summer school, 6/28 of 22. Pick up, drop off, no issue. That's why it's so bad.
Mr. Phillips, please, only when a question is raised. And is it fair to say that around July of 2022, that you and Ms. Green, towards the end, let's say, based on your timeline, after July 19th, 2022, that you and Ms. Green were having disagreements, that you essentially were not seeing eye to eye as it related to Jalen? Yes or no?
No,
No, that's not true? Or no, were you guys having disagreements as it relates to Ms. Green?
it's not in regards to Ms. Green.
No, I'm sorry. Were you having disagreements with Ms. Green about Jalen?
For a safety plan.
Okay, but you were having disagreements as it
I wanted-
relates to Jalen,
No, it was only in regards to a safety plan
for Jalen.
from when he's in my home with me and then also with her,
Okay,
because the ideation was in regards to a knife and I don't want to cut us.
Mr. Phillips, please.
Okay,
please.
sorry, I'm just giving context to your question.
Did you have conversations with Jalen about your position regarding his school that differed from his mother's position?
We have joint legal custody. We both are supposed to agree.
That's not what I'm asking you,
Okay.
Mr. Phillips. I'm asking you whether you expressed to your son, Jalen, about your essentially, about your feelings, your negative feelings about Miss Green and where she stood with Jalen opposed to where you stood with Jalen's school.
No, so my
Judge,
son,
I'm gonna object, just in the interest of time. It's not relevant. His view on the kid's school and her view on the kid's school doesn't go to whether he's talked to her or not.
Judge,
whether they agreed or disagreed, it doesn't really matter.
It is relevant because now he's stating that they had a fine relationship and that he wasn't aware that she didn't want him coming over and that they were not blocked or anything like that, when the information that I have shows otherwise, and that they were not in this sort of cordial relationship as the defendant is leading to believe.
Judge, it's a secondary issue. If it's a secondary issue, you don't get to introduce extrinsic evidence.
I'm not introducing extrinsic evidence. I'm merely asking questions.
But that's what she wants to do. She doesn't want to accept the answer, so she wants to get to extrinsic evidence on an issue that's collateral to what we're here for. We're not here to decide the schooling issue. We're here to decide if the man stalked her or not, and this doesn't go to that.
It does. It goes to his feelings and motive towards the complainant.
I'll allow it. Let's not get too deep in the weeds.
Okay. Did you text Jalen in saying that Miss Green is purely evil?
I did say that.
Okay, thank you. Did you text Jalen and indicate that Miss Green would get herself in big trouble playing? There's quite a history of her lies and games.
Show me what you're reading, and so I can confirm it. So you don't
I'm
put
just
words in my
asking,
mouth.
did you say
Show
that?
me, please. Thank you.
You're able to remember whether or
Yes.
not you indicated.
Well, because now you're saying things, and now I'm remembering I need to see because everybody else was shown. So I would like to see it, and I think that's only fair. Yes, and above that is the.
No, there is no
that's not
above
what I'm
that.
asking you.
Oh.
I'm saying,
Answer
is
the
that a
question.
statement that you made in regards to Miss Green to Jalen?
Yes, can I read it?
Okay, I thought you did.
No, like, can I read it?
No.
On the record? Oh, okay.
No.
They should hear it.
So, the video that was shown earlier, that actual video had no date and time on the actual video. Is that fair to say? The one that we all watched together. There was no date or timestamp on that video showing you enter into the Hilton.
He showed me two, or he showed me.
He showed you one video. He showed you a still
Yeah.
shot.
So.
Mr. Phillips, you were shown
Yeah.
a video, yes or no?
Yes, I was.
Okay, that video was of you allegedly at a Hilton, is yes or no?
I was there.
Okay, where is that Hilton located?
Hilton Garden Inn, right behind, it's in a theater. There's a promenade of like restaurants in Novi.
I'm just asking.
it's in Novi.
Okay, thank you.
No road? What road's it on?
That's why I'm giving the location of the.
No, you're talking about what's around it.
Yeah.
If you don't know what road it's on, just say you don't know.
Yeah, I
You
wasn't a
don't know?
resident
That's
there.
okay. And you're allowed to say I don't know or I don't remember.
Right.
Those are perfectly fine answers.
I did send it to your email a year ago.
Mr. Phillips, you were shown a video, yes or no?
Yes.
And that video was of you allegedly entering into a Hilton, yes or no?
Yes.
Okay, and on that video, is there a date or time stamped as to when you were present at that Hilton, yes or no?
That is correct.
So no, there is no date or time
Oh,
stamp.
I believe there is. I mean.
On the video,
yeah.
Mr. Phillips, that you were just shown.
Yeah, I believe it was.
Was there a date and
I'll take
timestamp?
judicial notice for the jury that the video had no date or time.
Thank you.
Oh, I thought it did. What I just seen, it did.
You're wrong.
Oh.
Move on.
And so that video does not actually prove that you were somewhere on January 14th at, let's say, from 9:30 to 10:15 p.m.
Cell tower data.
Mr. Phillips, yes or no?
The
The
receipts.
video itself that your attorney introduced and showed you,
Mm-hmm.
it does not prove where you were on that date and time. Is that correct?
No, it's not correct.
Okay.
And that's why I sent it to police
I'll-
and government
I'll move
to
on.
reconfirm.
Mr.
everything I
Phillips,
said.
we saw a video that you saw of Miss Green running into the police department at around 10:17 p.m. on January 14th. Do you know how far the Novi Hilton is from Miss Green's address, her location, the Saddleback? Do you know how far it is?
No, because I wasn't a resident at the hotel and I wasn't in that area or
Okay.
jurisdiction of
Do you
Romulus.
know, and you can say you don't know, that's fine. Do you know how far it is from Novi to Romulus?
I don't. I
Okay.
didn't travel that route.
Okay,
and I wasn't
that's all I'm
there.
asking.
Okay.
Sorry, it's loading now. Oh. So I don't know if this will work because now there's traffic, so it added time to it. But earlier when I had checked, Judge, it was ranging from 25 to 28 minutes. Now there's traffic, so it added time. But without traffic, essentially, I think we can say roughly 20 to 30 minutes, I think would be fair between the hill.
Does that Google map show you how many miles between point A and point B?
It does. It would be 24 miles.
Any objection to that?
I think that would be about a half hour to 40 minutes. I think that's.
Depends on traffic.
Even
I
without
would not
traffic.
say right now it shows traffic and it's saying 35 minutes. Earlier when I checked without any traffic, it said 28 minutes.
I used to go to meetings there. Depends on traffic.
Right.
I'll take judicial notice.
Okay.
A half hour roughly. Give or take a couple minutes. I'm not gonna wobble about it.
All right. Any other witnesses from the defense?
No, Judge.
All right. Any rebuttal witnesses from the people?
No, Judge.
All right. Are you guys ready to close?
Judge, can I just have 5 minutes and then I'll be ready?
Let's do this. Why don't we let them take a break? You guys can prep for close. We'll go over final jury instructions. Then while you guys are giving your close, Heather can be updating the tablets. So as soon as your closings are done, we're ready to go into the final instructions. Does that make sense?
Fair enough.
Okay. So here's what we're gonna do. One last break, then the next time I give you, let you leave the courtroom should be for you to go in and make your final decision. So once again, you can leave your notepads and everything there if you want to. So let's take a break. You guys go ahead and stretch and then be prepared to go over the instructions. And what I tend to do is after we get done with the instructions, I tend to want to go in and read them. So remind me, you get closing arguments before I read them. Because I always miss that. Once they start talking. Yeah, I keep forgetting you can do that. We've got 1, 2, 3, 4, 5, 6, 7, 8, 9 paragraphs. Any of that should not be in there?
I guess paragraph 4 talks about likewise the fact that he or she is charged with more than one crime in the brackets.
Yeah, I think we can delete 4.
Just the part that he.
Yeah,
Yeah, the more than one crime, yeah.
correct.
Yeah.
None of them asked any questions to witnesses, right?
So just likewise with that, but that's fine. Yeah.
The fact that she's charged with a crime in this trial is not, yeah, that, yeah, just the parens we're gonna drop. Yep. 5, okay, 6, okay.
I think the bracket stuff doesn't apply. There was no commentary. They didn't submit any questions.
Your questions, yeah, okay, I'm with you. Number 5.
Number 5.
Yeah.
The commentary.
The two in brackets sections, sentence 1, line 1 and line 4. All right.
Any commentary on your questions to witnesses?
6.
Same thing.
Yeah, I don't think there was any summary of evidence. 7, okay.
7's good. 8's good.
9, okay.
Yes.
All right, so what do you guys want to add?
It would not, it's not,
Doesn't go here?
no.
I wanted 4.5 about.
That would be on witnesses. That would be the next section.
Okay,
All right, so we're moving into page 3, witness credibility.
yes.
All right, paragraph 1, okay.
Yes, this is just.
2,
Yes.
no problems with 2. How about 3?
3 is fine too.
Say again.
Yes,
That's fine.
3 is fine.
Okay. And you want to add one of the sub paragraphs in 4, Mr. Kuja?
What was that, Judge?
You want to add something here?
Yeah, I wanted
He's
to.
on the next page.
Oh, okay. So we're all right. So this, everything we've got under witness credibility on page 3, you're okay with.
Yes.
Now we're going to look at page 4, correct?
I think this would go under page 3 though.
Okay.
Instruction 4.5 about prior inconsistent statement used to impeach witness. I emailed it. I emailed it right now.
And
I'm adding something.
Ms. Bush, you're okay with that? Or you're
Yeah,
looking
no,
at it?
that's fine.
Okay.
It
So
happened in the.
Heather's going to add that language.
And then there's another one for page 5 for time and place. I would like to add the, only because,
Hold on, you're jumping ahead of me. Don't
Oh,
do
I'm
that.
sorry.
I'm old and easily confused.
oh, I didn't realize we didn't do.
All right, so page 4, elements of the crime, you're okay with the way it is?
Yes.
Basically the same way I gave it in the
Mhm.
opening instructions.
Yes,
All right, so now page 5, you want to add to what we've got there?
yes.
All right, what do you want to add?
Under 412, it says essentially, I'm trying to pull it up right now.
Are you up? You caught up so far?
No, I have a big.
No, I mean, you're catching everything.
Oh, yeah. I have to wait till she sends it.
Yeah.
Judge, it's 412 is a time optional clarifying instruction, essentially that the prosecutor says that the crime took place at blank and, you state blah, blah, blah. The prosecutor also says that the crime took place on or about, state it. The prosecutor does not have to prove that the crime was committed on that exact date, but only that it was committed reasonably near that date.
Okay,
I think that's
So I would like
covered
to
by
add that.
the original time and place instruction that's given. Prosecutors prove beyond a reasonable doubt that the crime occurred on or about July through August and January 2023. So
yeah,
you're
because
wrong.
we
I
don't
didn't
have any,
see-
we
I
don't have any
didn't-
specific dates in
Oh, I
that.
didn't notice that. I'm so
Yeah.
sorry.
I think-
That's
think-
totally fine.
Yeah, I think this one's like.
Yeah, and that saves Heather some work
Oh,
too.
I'm sorry. This is
Okay. All right.
the
So that's
range
fine.
of it. Okay,
All
never
right.
mind.
So deliberations and verdict, moving on.
Fine with me.
Any objections on 1 through 5, paragraphs 1 through 5?
No.
No, Judge,
All right, so penalty, communications with court.
it's fine. Did we do that? Yeah, we did the police witness one.
I think we should leave exhibits and hope they don't want to watch the videos again because we had so much trouble with them. But I think we should leave it there because it talks about taking their notes with them and
Yeah.
the final instructions go in. Are you agreed?
Yes.
All right. And then the verdict form, which you two have not had a chance to look at.
Yeah, she emailed it over to me.
All right. So you guys saw it before I did.
Yeah.
Okay. All right.
Judge, am I missing the place where it talks about like a police witness?
Yeah, 511.
No, I should have been in here.
Thought I heard you say it at the beginning. So
No,
Is that on the next page?
I
I
don't
know
have
you
a
said
next
it in the
page.
beginning, you went over it. But that and then the,
I think that should be in,
Oh, do you?
I think it's in another section, because that one and then the weighing conflicting evidence.
Yeah.
Number of witnesses.
yeah,
It's because it's, Judge, there's final instructions, evidence instructions, and witness.
right.
instructions.
Right.
Okay, I didn't
Yep,
notice that.
yep. So let's,
Okay.
all right, we're okay with final instruction. We're gonna move into evidence now, right?
Yes.
Agreed?
Agreed, Judge.
Page 1, defendant's statements as evidence against the defendant. Yes or no?
I don't know that it applies.
I don't think it does.
It doesn't apply. This one is only for,
So take out 1 through 3.
yes.
Yeah, the whole
That's only
instruction
if a statement is given,
for, yeah.
I don't think circumstantial evidence really applies here either.
Judge, I would request to leave that, because I do think that, some of the information that was described would be considered circumstantial.
Any strong feelings one way or the other, Mr. Kuja?
Not really.
I mean, certainly, we don't have the classic, raindrops on the raincoat type
Yeah.
thing, but
Yeah, everything that they both said was they claimed that they saw it. We're just saying which one's telling the truth.
what do
which
you,
one's
what do you
not.
think we had today that came from the stand that would be circumstantial?
Well,
I just don't like to throw it in there if it's not necessary, because it
no,
can
and actually, the testimony
send them
was
down a
little-
rabbit hole.
was a little different than I anticipated in the beginning, when I thought there was gonna be a little bit more circumstantial evidence, so.
I don't think we got much.
So
though.
there wasn't that much. I would say maybe like the video of her running, what does that mean? Why is she running? Inferences that could be made based on things that she
That
did
doesn't,
earlier.
yeah, but I don't think that makes the circumstantial evidence. It means it might mean something different to you than it does to the defense. I mean, I think that's on what's it mean, not what type of evidence it is.
To me, it doesn't hurt to have this on there. I've never had it removed, even if circumstantial evidence isn't there, just because of, them understanding the differences between the two.
So this is not charged.
Yeah.
Mr. Kuja?
Yeah, Judge, I've never had it where we went through a whole trial without any circumstantial evidence, but yeah, I don't think there was. I think it was all direct.
Yeah.
We're just saying,
Right.
who's truthful, who's not, really.
I'm gonna leave it in though.
Okay.
Just because I don't. If prosecution wants it, and I don't think it's gonna be too big a deal, I'll leave it.
Okay.
The
So,
next one shouldn't.
yeah, we should delete
that
1,
should-
2, and 3 under flight.
Yeah, that shouldn't be there.
Prior inconsistent statement, there was a lot of talk about that, but we never really said, so this is your statement. But we talked about it enough, maybe the instruction would make sense.
We talked about, each one was
Yeah,
kind of impeached
yeah.
with different things. Yeah, that
Yeah.
makes sense.
Ms.
I don't
Moisisian,
I don't have an objection. to
Okay.
that. Leave it or no?
leave it.
Okay.
Stipulation on page 2, I don't think we really had a
Didn't have it.
step.
We'll get rid of that.
Maybe the Google thing, but
The
that
Google,
was
yeah.
just,
But I think that's different than the.
I do
stipulation.
too. That's the closest we had though.
I think
Yeah.
there is an instruction on,
Judicial notice.
judicial notice. I've used it before.
Yeah, I think it's kind of the same thing. We all stipulated to it, they give it whatever weight they want to give it. Right?
I'll find it.
Well, we didn't use the phrase stipulated, but do you have a problem with that? And we went back and forth on it.
Right, yeah, we kind of ended up agreeing on this.
Let's get through this, Ms. Moisisian, and then if you can find the one about judicial notice, we'll look at that too.
It does, Judge. It's 4.6. In this case, I took judicial notice that state fact. This means that you may accept the fact as true, but you are not required to do so. I do think for 2 of those things, for the fact that for the video not having the date and time, and then the location, I think both of those
Okay.
can be used on.
Yeah, I
All
think the video doesn't really need to be part of the judicial notice thing. I was just an exhibit. You can observe it just like us and the jury can observe it. There's no timestamp on it.
Well, the only reason I think we should include it is because when we give them an instruction about judicial notice, I use that phrase to them. I'll take judicial notice that the
Oh,
video.
Yeah.
So that's the only reason I think we should talk about it. So what I'm going to ask you to do is draft it exactly the way you want it read. And then Mr. Kuja can look at the way I'm going to read it. And then if there's any,
Yeah.
Difference
just
about
think the judge-
language.
The problem, I think with including it as a judicial notice is just, the court's observation of an exhibit, just like anybody else's. I think it just draws more attention to it now. And it's probably evidence that's more favorable to the prosecution. Now we're drawing more evidence to it, but it's really, I know you use the phrase judicial notice, but that's not really a judicial notice.
I don't feel strongly about it.
I would
Ms.
just say,
Moisisian,
the only thing that's really actually judicial notice is the Google Maps.
the mileage.
I would say for both, solely because the defendant would not answer my question, and you had to say that there, based on the video that was shown, there's no time and date stamped on it.
Yeah, I'm going to give him this one. And the difference is because this one, we've got the actual video if they want to look at
Right.
it. I mean, I hope they don't, but if they do, we'll have to send your laptop back with the court officers.
Okay.
All right, so let's, as far as the judicial notice instruction, let's just talk about the distance between the hotel and Saddleback.
Okay, thank you, Judge.
And then motive,
Well, I guess that,
any feelings on that?
no,
I've never removed it. I think I generally do them in any of these sorts of cases.
I'm okay.
So leave it.
Mr. Kuzic?
yeah, I don't have an objection to it, Judge.
Okay. All right, so then we're moving on to witness instructions, I believe. Paragraph 1 does not apply.
Correct.
Witness.
Actually, 1 and 2 don't
That's
apply.
all, yeah,
And
that's.
the lane.
I don't think we need that either. Well, I don't know. We had more. We had two to 1. Yeah,
Could do
Yeah.
that.
she had twice as many. So yeah, we'll leave weighing conflicting.
Okay.
There was no impeachment by.
No, I don't think there was any. I don't think there was much conversation about interview with a lawyer. Either one of you feel one way or the other on that one?
No.
No,
Take it out?
I would remove it.
Yeah.
Okay. We heard some veiled reference to character evidence, but
Did we?
I think it might be more confusing to leave it in, but I'll let you guys make an argument.
Yeah, I don't think we got into character.
Sorry, I'm just reading.
That's all right. Take your time.
Yeah, defendant's character for peacefulness, honesty, and being law abiding.
Yeah,
We didn't get
that's,
into that.
I would remove it.
Take it out. Paragraphs 1 and 2.
I agree.
Same with the expert witness 1 and 2.
Yes, Judge.
Yes,
And then police witnesses, obviously want to leave that there.
Yes.
Agreed?
Agreed.
So intense that she reportedly drove straight to a police station and ran inside like a nervous wreck. Prosecutors argued this wasn't one isolated moment. It was a dangerous pattern of behavior that made the victim feel unsafe in her own home. From threatening motions to repeated late-night encounters, the courtroom heard chilling testimony describing fear, intimidation, and emotional distress caused by the defendant's actions.